Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. She is a professor, speaker, investor, attorney, and a single parent. I'm very happy to have here my next guest on the SEP Couch, Christa Laser.
Hi, nice to meet you.
So good to having you. And now I did the mistake. I said Laser instead of your name is Laser. I'm German. I'm excusing myself here directly, but it's so good to have you here. And I'm starting like with any guest to get more information about who you are. And since we're talking about SEPs, it would be great if you could walk us through a little bit your career, your steps on your professional way. And where did you get in touch with SEPs and where was that important in your life?
Yeah, thank you so much. So I am currently a professor at Cleveland Marshall College of Law, where I teach innovation and intellectual property law among several first-year courses. And I started teaching about a year and a half ago after spending nearly a decade in practice. I practiced at the law firms WilmerHale and Kirkland & Ellis, and I did intellectual property litigation at those firms. So I did intellectual property litigation in the patent space and also copyrights, trademarks, and false advertising as well. Most of my work in the patent space was divided between technology litigation and pharmaceutical litigation. So in the technology space, standard essential patents are critical for ensuring interoperability of technologies and also making sure that companies can have agreements that apply internationally for all the uses of their products. And we can make sure that we have that interoperability, not just in one place, but in every country in the world. So standard essential patenting practices have come to the forefront, and it's also created a lot of litigation in the patent space, because you could imagine that essentially when a company decides to incorporate a technology into a patent standard, they also agree to license their patent on fair and reasonable non-discriminatory terms. And so you can get a lot of litigation that arises when companies are saying, hey, you're not licensing this patent to me on reasonable terms, or you're not licensing it to me at all, or it shouldn't be included as part of the standard. Or you also get arguments that they don't infringe or that it's not actually necessary to practice the standard. So those kinds of disputes can arise a lot in technology litigation. And I've had the opportunity when I was in practice to address a number of standard essential patent issues in the patent litigation space.
Yeah, that's very exciting, and glad you have had so much experience in that space. But I find it also always interesting to see people that also have been litigating in other areas. If you think about, patent litigation for semiconductor battery technologies, you've been even in biotech, a variety of litigation cases. How is that different to a SEP case? Where do we see more or less litigation? Any ideas on that?
Yeah, so litigation can arise in any context where you have disputes, but those disputes are going to be different. So in the biotechnology space, for example, many of the disputes are not necessarily questions of infringement, especially if you get into pharmaceuticals, because the parties largely agree what the compound looks like and how it's used. And they're mostly trying to figure out whether it's valid, whether that patent is valid, and then also trying to figure out competition issues around those patents, like whether the party seeking the patent or who's obtained the patent has engaged in anti-competitive conduct in obtaining that patent. Now, that type of conduct is very different than the conduct that you would see people argue as anti-competitive in the standard essential patent space. So in the standard essential patent space, you're often trying to figure out, does the product infringe? Usually that can be shown by saying that it practices the standard and that the patentee has asserted that their patent is part of the standard technology. And then you can also get questions of competition. Anti-competitive conduct can arise in the standard essential patent environment if, for example, a company has disclosed some technology for inclusion in the standard Then the technology gets adopted, incorporated into the standard. People start to use it in their products. And then the company says, we've been seeking patent protection for this thing, and they obtain a patent. And then everyone that's participated in the standard sort of gets surprised about, well, now we have to pay royalties for this thing that we didn't think we were going to have to pay royalties for. Now, most of the standard setting bodies have agreements that require parties to disclose what kinds of patents they're going to be seeking on the technology that they're proposing for inclusion in the standard. But many companies will disclose that with strategic timing in order to induce people to enter into, to accept that as part of the standard before realizing how much that technology was going to be subject to patent protection. So this can create a lot of issues where you might be able to argue, if you were defending against that patent, that, hey, that conduct was anti-competitive, or at a minimum that conduct breached the agreements that the patentee signed as part of the standard setting body. Of course, the remedies might be very limited when you're talking about, what can you do if somebody breaches those agreements? That's very different than the kind of remedy you might get if you can say this is a complete defense to patent infringement, or at least can prevent an injunction or something like that.
Yeah, no, that makes a lot of sense. And I think in some cases, you don't even have the choice. If you want to be, participating in a market, you have to comply to the standard, right? So it's not even that you have much of a choice if you want to add certain features or not, right? So it's quite of a different situation, I guess.
Mm-hmm. That's right. Yeah, I mean, you can always make a choice in the biotech space or in the mechanical arts space to say, I'm not going to use that technology. I'm going to design around it. I'm going to use something different. But you don't really have that choice when it comes to incorporating the standard and complying with the standard.
Yeah, no, that makes a lot of sense. There's another complexity I keep seeing, and I think the industry has difficulties with, is that these licensing negotiations around SEPs and FRAND and what FRAND is are typically global negotiations, right? Which makes sense. I mean, why would I carry my phone and I'm traveling to the US? I want to have access, and I shouldn't be infringing patents there, same as in Europe. I mean, it's a global thing. But the issue is litigation is local courts, right? And that has led to some, I would say, friction or complexity, at least, with certain courts making decisions on global rates. What is your experience, or maybe also observation in this? Why is that so complex? And could you elaborate? I'm not a lawyer, I'm not a law expert, to people that are maybe not in the details there, why that is?
Yeah, so as a matter of my own background, I participated in an amicus brief in the Samsung and Ericsson case that related to the question of anti-suit injunctions. Now, an anti-suit injunction is an injunction that one court that's deciding an issue issues in order to prevent other courts from trying to decide the same issue at the same time. So it's designed to make sure that a set of litigation or a set of questions are going to be decided in one court at a time. Now, this is important because, as you say, patent litigation is local. It's country by country. And that's the case, even though all of the potential infringement that's occurring around these standard essential patents is global. As you said, you bring your phone to many different places. There are many technologies, for example, around 5G, video compression. There's plenty of patented technologies that are based on standards that are incorporated into various electronic devices, because that's a critical area of necessary interoperability. And this is something where we want that interoperability to apply internationally. And so many of these standard setting bodies will adopt standards that apply internationally. And then when a company infringes those patents or adopts those standards in a way that someone asserts to infringe their patent, that company the patentee has to find which country they want to sue in. Now, they can choose to sue in the United States if that infringement is happening there. They could sue in China, they could sue in Germany. There are many places where they could choose to bring that lawsuit. And there are strategic choices around that. Some of those choices are around what types of legal protections are available in the process of that litigation. Some are substantive. What is the likely outcome of this litigation in these courts? Is this country more likely to find those patents invalid? Is this country more likely to set a rate that is lower, a royalty rate that is lower, or a royalty rate that is higher? The United States, I think, sometimes has had juries award rates that are higher than you might see in some other countries. And so some people might choose to file there. Although some of the due process protections might also be higher in the United States in terms of seeking discovery and protecting against evidence that may be misleading or anything like that. And so that's been the complaint when people have filed lawsuits, for example, in China, as happened in this Erickson case. One of the complaints has been that the due process protections available in China are not as high as they are in the United States. But on the other hand, we have to make sure that every jurisdiction, every country is respecting the laws of other countries, respecting the legal process that happens in other countries. And if we don't do that, we have chaos. You know, we have two countries deciding the same issues, might be overlapping, and then the parties have to figure out, well, which of these do we apply? If China sets one rate for the royalty for these patents and the United States sets a different rate, which rate is supposed to apply? Are you supposed to apply one rate in one place and one rate in the other place? These are supposed to be international agreements. So it can create a lot of complexity. So the anti-suit injunction is something where one court says to the other court, no, we're going to decide this. Please stand by until we decide this issue. And then there's something called an anti-suit injunction, which the court, let's say if China issues an anti-suit injunction to stop the United States from pursuing the determination of the FRAND royalty rates, then the court in the United States could issue an anti-suit injunction that says, no, we're going to continue to proceed with this litigation. Now, the brief that I participated in was arguing that this kind of back and forth between countries creates a lot of inefficiencies and problems, and that we should be trying to respect the court systems in other countries.
Yeah, sounds a lot of complexity, but you explained that very well. Thank you so much. And in that regard, I keep hearing also things like forum shopping. You know, how would you think about that? You know, not even across countries. I guess there's even forum shopping within, let's say, the US. Certain courts
Yes.
are famous or have reputation to be pro patentees or pro licensing. What is that? You know, what is your experience there?
Yeah, that's true, and that shifts year to year as different laws and standards get adopted in the United States. This question of forum shopping is something that lawmakers have been trying to address and work through, and how many recent court decisions have affected where you can file your lawsuit in the United States as well. Historically, one of the places that is most friendly for patentees has been the Eastern District of Texas. And in part, that was because juries tended to be more favorable for the patentee in those scenarios. There was a persuasive argument that could be had if you come, you waive the paper from the patent office and say, you know, the good folks at the patent office granted this and are, you know, relying on us to enforce it. And that's something that can have more weight in regions like Texas, where there is just more of a cultural respect of that sort of thing than there might be in places like Delaware. Now, there are still plenty of patent lawsuits that happen in places like Delaware, in the Northern District of California. And a lot of those are because that's where those companies are located. So many of the new rules about where you can file your patent lawsuit depend upon the location of the person being sued or the company being sued. And so that's why you still see many of these lawsuits happening in, for example, Northern District of California or Delaware, because that's where many of those companies are based. Also New Jersey for a lot of pharmaceutical patents. But still, many patentees try to find ways to bring those lawsuits in Texas in order to take advantage of, at the time, more favorable juries, and now more favorable procedures for deciding those patent cases.
Okay, that makes sense. How could you argue that? I mean, do you have to just sell there, or they just open up one branch and that's enough?
So typically, it's where your where your main place of business is. But companies have certainly been trying to move operations out of Texas in order to avoid the potential for getting sued in that area.
Okay, so we see more lawyers in Texas and less people that work at the headquarters, I guess.
That's right.
Very, very good. And Christa, I can see you are great in explaining very complex things in simple words.
Thank you.
And that also ties to my next question. You are not, in practicing law for law firms anymore. You changed your career path and you became a professor now. How did that change in your career? Maybe also change your perspective on these legal matters?
Yeah, that's very interesting. So one of the reasons that I decided to go into teaching is that I wanted the opportunity to be able to say what I thought was right instead of arguing something in favor of a client. And oftentimes, you can come up with an argument for either side when you're a lawyer. There are always good arguments on both sides. And there's, good ethical arguments that you can make on both sides for an issue, even if you disagree with it. So, your job as an attorney for these major corporations is to make sure that you are bringing up every possible argument, every creative argument that you can come up with to favor their position. And that might not always be the outcome that's best for society. And so one thing that I pride myself on now as a professor is that I can write what I think is correct, what I think ought to be the answer. I can look at these issues and say, this is what I think would be good for society. So sort of representing that balance of interests between technology companies, which are very important and serve a critical function for making sure that we have the quality of life that helps us and makes us happy, and also individuals and society, and making sure that these companies are not engaged in anti-competitive conduct, and making sure that we do have a balance of rights, that we have a balance of protection of intellectual property versus the advancement of science and innovation in a way that's beneficial to the public.
Very good. And for your students, I mean, you've been practicing also for almost a decade. How do you take that experience back to them? Are your lectures very practical? You use a lot of case studies. How does that work?
Yeah, so my method of teaching is called the Socratic method. And basically I have my students read cases, and then I ask them questions. Why did the court reach this result? How would this result be different if this fact were different or that fact were different? And then I also ask them to argue both sides. I tell them, look, even if you don't agree with something, your client is going to need you to come up with every possible argument that you can in its favor. And that's the duty that you owe to your clients. And so I ask my students in class, how can you think of an alternative argument here? How can you argue for the side that might have this or that issue popping up? What kind of evidence do you think that you might need? And I use my practice experience to lead them in that direction with the questions that I ask. So, for example, if I were looking at a case about standard essential patents, I might ask them a question like, can you think of arguments as to why the conduct that the patentee engaged in here might be anti-competitive? Can you think of arguments as to why that conduct might have breached the agreements in these patent licenses that the patentee had offered? And so you try to get the students to engage on both sides of those issues in order to prepare them for practice. And some of my students end up going into policy making as well. So I try to ask them what outcome here would be the best outcome for individuals, perhaps in this state, perhaps in the country. What about nationwide? So for example, I have a seminar that I'm teaching right now called Innovation Law that addresses global policy issues in innovation. And one of the questions that arises, for example, in a topic that we're discussing in about 2 weeks, is around pharmaceutical patents, and whether having more patent protection leads to more drug development and leads to better health in the areas that have those higher levels of protection, but also can lead to much higher costs. And how do you balance that out? So there's some really interesting issues and in policy that you want to come up with and get students to think about. So I do try to incorporate practice, but also policy into my lectures.
That's interesting. I'm an economist, you know, and I also have a PhD in this, and that's exactly those questions that I tried to answer back then. Like, what are the effects, and what kind of incentives does the patent system create? And that's really interesting. I mean, for, as you say, economies and societies, and very complex aspects to it, and not easy to argue, to be honest. But yeah, that is great, and sounds really exciting to be your student. I'm sure.
Thank you.
And you've come a long way. I started like this. You are a professor, speaker, an investor, attorney, and a single parent. So how did you manage to get all this together? How, you know, you wear so many different hats. Sounds very challenging, and you have my full respect for that. What is your special sauce here? How did you manage to get there?
Yeah, so it was very difficult, I will say, especially in practice. When I was in practice and I had two young kids, I had them a year and a half apart, so it was very difficult trying to manage working those long hours that you have in big law and having a toddler and a newborn at the same time. It was very difficult, and there were days where I wasn't able to get the work done that I needed to get done, and it was only because of the grace of the partner or whoever I was meeting with that everything worked out okay. So I think the most important thing that I can sort of urge people to do is, if you do have people who are single parents, or at the time I was married, but still a heavy load falls on women, especially, I think, still these days, that have grace for those people. Make sure that you're trying to incorporate work-life balance as much as possible into your workplace, and that you're trying to support people with their personal goals. So one of the things that I really appreciated was when a junior partner, or whoever I was working with, would say, look, I know you're dealing with this issue or that issue. Is there anything that I can sort of do to buffer that? Because otherwise it can be very difficult. I mean, I remember days where, because I had clients that were in Korea or at various places all across the other side of the world, I would have calls at 9:30 at night that I had to be on, some weekly conference call at 9:30 p.m. And in the meantime, I'm struggling to get the baby down and then running to the conference call. It's incredibly difficult. I will say that definitely work-life balance is a lot easier as a professor than it was in big law. But I want to make sure that I'm encouraging my students to, who hopefully, many of them will be parents while they're practicing, to tell them to be open and vulnerable with the people that they work with, to make sure that they understand the struggles that they're going through. That's the only way that people can actually help you with that.
And you said something interesting. You said the heavy weight of childcare is still with women.
Yes.
In general, I mean, you're a strong woman. You have a strong voice, maybe even a role model for pursuing your career while having kids. So that is possible, but still, it's more difficult for women than for men. Why do you think is that still the case? And how should we as a society change that? Maybe not maybe, for sure. And what are ways to get out of this, to have more equality?
That's a great question, and thanks for asking it. I think there's micro and macro solutions to that, and I'm not the expert on it. I can only speak from my own personal experience. But on a micro level, I think it's really important, for women to choose partners that are going to be supportive of their careers and view their careers as equally valuable, and then have conversations in the home about balancing that division of labor. And then in the workplace, for employers to have procedures in place that help to encourage men to also take time for family. So one of the things that I really appreciated when I was at Kirkland was that they had a parental leave policy that was equal for men and women. And that encouraged men to also take some amount of paternity leave. And when you have both men and women taking paternity leave, you can have less of a hit to women for having kids, because you don't have that, oh my God, she's out again, all this stuff, if men are taking it too. And then you also have the men spending more time with the kids and getting that early bonding so that they do feel prepared for taking care of children in those early years and helping with all of those tasks. So making sure that you do have that balance between men and women, both in the home and also in the workplace policies, is really valuable. And, also encouraging men to actually take that leave, because what you don't want to do is offer that and then have some kind of expectation that men are not going to take the leave. That's a problem.
Right. And that's, to be honest, what it is. I think often in Germany, we have all that, but it's still, the statistics are frustrating, really. But it's not only about, there are good examples, and it's great that Kirkland has that, but also many times, even earlier, when you apply for a job and they look at you, okay, you are in your mid-20s, she's probably going to get kids, she's married, that thought alone, right, is not equal.
Oh, no. I've had plenty of, even though it's illegal to ask those questions, I've had plenty of potential employers ask me, when are you planning on having kids? Are you planning on having more kids? All of that stuff. So, I tend to just try to be honest about that, and hope that the employer is the one that's going to do the right thing there. For me, I would love to have more children and get remarried. And so I told potential employers that ask that question, yes, I do want to have more. So what are your maternity leave policies? But I think that's something that it's good to be open about, because then that employer, can, if they're going to be making a decision not to hire somebody based on that, then that's not a place where I want to work. And, I know my value now enough to make that choice. That's not something that I had the power to do earlier in my career.
Yeah, no, I can see that. And I know from my own experience, hiring women that had or have children are the most efficient, most best organized employees you can have. Not that I have statistics on it, but a very good experience. And I think it applies to many other areas as well. I think still, especially in our area, especially in intellectual property, I've seen statistics on inventorships, on patents. It's highly dominated by men. It's still not very diverse, to be honest. And I think there's a lot more we can do, right?
Yeah, that's very true. And thanks for asking that. So I do think that this is something that the Patent Office in the United States is trying to address. They have a number of working groups to try to address diversity when it comes to who is registering for the patent bar and passing the patent bar. They've been trying to find ways to increase the eligibility. So for example, design patents, there's really no reason why someone would need a STEM background in order to prosecute a design patent, but we still haven't really done enough to update those patent examiner requirements to make sure that they aren't imposing additional requirements on people that are necessary. And then I think also encouraging women to get into STEM from an early age is really important. And the biggest thing that one could do there, I think, is having role models, encouraging women to become interested in those sorts of things. That it's difficult, and I'm certainly not the expert on figuring it out, but we have a lot of people in the policy space working hard to try to get more women and minorities involved in tech. And as you get more women and minorities involved in tech, you'll get more people who join the patent space. You'll also get more people who join the investor side of that as well. I think I mentioned when we were chatting another time that one of the important things in investing is that many people will invest in companies with leaders that look like they do or that have the backgrounds that they do, whether that's investing in companies that are run by white men, or whether it's investing in companies by people that went to the top schools or something like that. And sometimes women and minorities don't have access to the same resources in order to get to those top schools, or in order to have the same backgrounds that those male CEOs have. And so a lot of investing groups that I'm involved in have been focused on trying to find women-owned and minority-owned companies that are equally worthy of investment. And the research has panned out really well that when you invest in companies that have diverse leadership, that those companies are more likely to generate a profit. And there's also data around investing in women-owned companies that they're less likely to get into legal and ethical trouble.
Yeah, very, very exciting thoughts here. And I think there's a lot to do. I think we can agree on that. And I think all these topics are easily to apply to the IP space, to the tech space in general. There's a lot we can improve here. I think, Christa, you are a role model, at least the way I see it.
Thank you.
A lot of good work you do, teach your students, and keep writing those papers. I ask all my guests here on my SEP Couch what you want to keep the people remembering, our listeners to remembering. So what would that be? What do you want the people to think about?
Yeah, so I'll circle it back to the standard essential patent question, because we talked about that a little earlier. I think it's so important for intellectual property to go global, and we need more international agreement and more coordination between countries on intellectual property issues in order to make that process go smoothly for companies as they continue to become more and more global and as people move more freely between countries. I think it's critical for the human race to eventually get to a point where we have excellent cross collaboration between countries, and standard essential patents are a critical way to get there, as are having great agreements for following standard essential patents. And that also requires having international agreement on judging those issues in the standard setting process.
Christa, I think I can very much agree to that. Thank you so much. Christa Laser here with me at my SEP Couch. You have a great day. Thank you.
Thank you so much. I appreciate you having me on.